First of all, I just want to say thanks to all of you for coming today. I'm Jan Crawford. I'm the legal affairs correspondent for CBS News. And I would like to say a special thanks to the Federalist Society for assembling yet another all-star group of attorneys to analyze some of the major cases of this term. Lee Otis, Leonard Leo do a spectacular, Dean, of course, Jean, do a spectacular job of raising issues, of course, that are fundamentally important and then bringing people together to hash them all out from a variety of viewpoints. So today, as you all know, we're going to be talking about the upcoming term, which we assume will be starting on the first Monday of October with the government shutdown. I guess that's still, does anyone know? We are, yes, okay. The court goes through rain, shine, snow, and a shutdown. And this term, so far, may not be quite the Obamacare term, DOMA, but there are a number of, I mean, in terms of my experience covering the court, hugely significant and fascinating cases, a wide array ranging from campaign finance, affirmative action, abortion protests, legislative prayer, and then a number of key environmental, business, criminal decisions already on the docket. Of course, the court will continue adding cases until it gets a full docket, another probably 30, 35 more cases to conclude its docket for this term. And to analyze some of the major cases, we're going to tackle about 15 of them. So we've kind of ranked them, the ones that we see as having the most widespread potential significance and interest. We're joined now by 5 panelists, and those of you obviously follow the court. You guys know already who they are because they're really the top at what they do in terms of advocacy or analysis. But I'm just going to go ahead and briefly give you a quick introduction. Otherwise, I could spend like 30 minutes talking about them, and that would be eating into our discussion time. I'm going to start with Mike Carvin here to my left, which is obviously no one really ever says that to you. Do they? Mike Carvin is to my left. Mike has argued, I don't even know how many I can count, countless cases in the Supreme Court and in every, I think, federal appeals court. And he tends to shy away from the really controversial cases. He doesn't, he only likes to argue cases like affirmative action and voting rights and campaign finance and health care and that, really bland case called Bush versus Gore. So Mike really does have a full plate, and he does the kind of page one cases that we all like to talk about and cover, actually. So Mike started out, of course, he was in the Justice Department in the Reagan administration, and I have the distinct honor of saying that I was standing next to Mike Carvin when the Chief Justice, John Roberts, walked over to him and started giving him a hard time because Carvin had been quoted saying that Justice Alito had been his first choice on the Supreme Court. Some of you may appreciate that in this room, Carvin's judgment on that.
Another act of brilliant public diplomacy. So,
next to Mike, we've got Mary Beth Buchanan. She's a partner at Bryan Cave. She focuses a lot on white-collar defense, investigation, securities enforcement litigation. Of course, something she's very well suited to do because she was a U.S. attorney and the U.S. attorney for the Western District of Pennsylvania for 8 years, right? 8 years. Of course, she has the other, I don't know if this is a good thing. You were the first woman, and are you the only woman? Still only. That's not the good thing. The first woman to hold that position in the state of Pennsylvania. And she worked in the Justice Department, well suited, of course, for that job. She worked in the Justice Department 22 years. Make sure we're going in order based on my notes. Megan Brown, partner at Wiley Ryan, very significant appellate practice here. Worked as a counsel to 2 attorneys generals in the Justice Department in the Bush administration. She is very well versed in some of the issues that we're going to be talking about today, and was just named recently, I guess, as one of DC's rising stars by Super Lawyer magazine. So we all know what that means. Megan is going to be a true force and already is. Next to Megan, Neil Katyal. Neil Also, Justice Department, Deputy Solicitor General, Acting Solicitor General in the Obama administration, worked in the Justice Department many years, advising Eric Holder back in, that was a previous administration, many administrations. And in the court, has argued cases ranging, he kind of stays away from the controversial cases too. Like, he's argued cases like Guantanamo Bay, healthcare. So Neil, obviously, issues of crucial importance and interest. And I will also say that Neil, I read somewhere, is arguing 5 cases this term. Is that correct, Neil? Mm-hmm. So we should all say thank you to Neil for actually showing up today. He's got 5 cases he's going to be arguing in the Supreme Court. Next to Neil, Nick Rosenkrantz. Like Neil, is a professor at Georgetown, clerked for Justice Kennedy on the Supreme Court. I point that out because that's someone we're always trying to figure out. So we're going to be looking at Nick today for some super secret code for figuring out Justice Kennedy. He also was in the Justice Department in the Bush administration, worked as an advisor in the Office of Legal Counsel, and now is quite an expert on constitutional law and some of the issues that we're going to be talking about today. And I will say that we also, in this room, can say that the government shutdown has had, at least in one way, a positive effect on all of our lives, because Nick was supposed to be testifying at a House Judiciary Committee hearing today, and that was canceled. So as a result, we're going to have Nick for the full panel. Okay, so that's our panel, and I'm sure you guys all agree. We're all very fortunate to be here. I'm going to tell you what the format is. I think what we're going to do, just start off, because I'm so curious. I always want to know, so what's this term shaping up to be? Or what are you going to be looking for? Kind of the bottom line, or I'm going to ask each of our panelists to kind of give us, like, what do you see as most interesting, or whatever you want to talk about, that's coming up this term. And then we're going to turn to the cases themselves. Each panelist is going to be talking about 3 cases. We're going to spend about 15 minutes with each panelist. They're going to summarize a case. We're going to have a little discussion about that case. They'll go on to their next case. And then at the end, we are going to have time, because I've been admonished to keep this thing moving. We're going to have time for questions. So you guys will save your good questions, and no lengthy monologues, though, despite this one. Okay, ready to get started? I'm going to start with you, Mike. This term, not Obamacare, not DOMA. What do you see any trends that are emerging? Who are you going to be looking at? Chief Justice Roberts, is he going to be put on the hot seat again?
You're right. I don't think there's any of the blockbuster cases for political junkies. It's more of a term for, like, nerds.
Wait. But if those of you out there watching, this is going to be a fascinating panel, because those are really...
For all of you nerds watching, this is going to be a fascinating... and when I say that, look, what I'm trying to convey is there's very important, in my mind, issues which maybe are not immediately obvious. And the 2 that I think are very important is the court's trend to look at the structural protections of the Constitution, to look at the first 3 articles of the Constitution and talk about the kind of protections those give to American citizens, not so much in terms of what the Bill of Rights guarantees them. And the 2 headliners there would be the Recess Appointments Clause case, NLRB versus Canning, which I think Nick's going to discuss. That's a case that Jones Day is doing. My partner, Noel Francisco, will be arguing it. And it involves the circumstances in which presidents can appoint people during a recess, and under the D.C. Circuit's interpretation of that would be extraordinarily smaller patch of time than presidents have been asserting since World War II. So it'll have a profound impact, particularly as in these circumstances where you have a divided Congress and the president and the Congress are potentially at war. The other issue, which I think Nick's going to discuss, involves a very important question in Bond about whether or not the Congress, through its treaty-making power, can exceed the delegated powers to it under the Constitution. Can it get it involved in things that it couldn't get under, say, the Commerce Clause and the like? And I think that'll have a very profound effect.
And Mike is talking about a case, Bond, which the facts of the case, if you guys know, involved a very jealous and vindictive woman who tried to get back at her husband's mistress by smearing chemicals, right?
Yeah.
Am I getting this right so far?
Yeah.
On the car handle.
And whatever one thinks
And
about
now we're
that,
talking about treaties.
Yeah.
So you never know how a case is going to get to the Supreme Court.
that's true. Whatever one thinks about that behavior is a normative matter. I think, and again, Neil, correct me, they indicted her under the chemical terrorist.
Okay, we're going to get to bond in a minute. We got to keep moving.
Well,
keep
then
moving.
quit interrupting
I'm
me.
sorry.
I'm just
Okay.
all right, so we're done with bond. The other big case that I will talk about in more detail is Mount Holly, which involves an effects test under Title VIII, which I think will have a profound effect not only in terms of how we interpret civil rights laws, but how it can have a profound practical effect in terms of lending practices in the housing market. And I'll get back to all that.
All right, Mary Beth.
Yeah,
What's your bottom line on the term coming up?
I think this is a term where we're going to see the court going back and maybe looking at some of its prior decisions and answering some of the open questions, some that may have been left unanswered, and in some circumstances possibly even revisiting prior decisions based upon possibly the new makeup of the court. And I think there's a good example of that in the Fernandez case, which I'm going to talk about as one of the two criminal cases in which the case was argued at the time when Justice O'Connor was still on the court, Justice Souter was on the court, Justice Stevens was on the court, Justice Alito didn't participate, and now we have the same issue, co-tenant consent coming up again, and we have a different makeup of the court. And so from reading the dissents in the prior case and the briefs in this case, I think that's a really good example of that.
And there are other cases, I think, some of you, that I think this term we may really see the difference with Roberts and Alito on that court instead of the Chief Justice and Justice O'Connor. The abortion protest case could be one, legislative prayer could be one, campaign finance perhaps. So the new Roberts court, which not so new, a really good point. We may really see them break away even more this year from the Rehnquist court. Megan?
Yeah, that was going to be my main point. My three cases are in the First Amendment context, and you see, while there aren't real blockbusters on the docket for the term, there are many cases that really squarely raise, or could be seen as squarely raising, the continuing validity of previous precedent. So I think you'll see and hear lots of things about stare decisis, and people in the run-up to cases will be talking about whether the Roberts Court will be willing to jettison a previous precedent and what damage that might do and the reliance interests on that case. When I get to those cases, we can talk about those precedents in particular, but I think people will be looking to see, is Roberts going to continue what some call his sort of incrementalism, or will they take the opportunity to get rid of some heavily criticized or moderately criticized precedents that may be out there that are vexing, and that to me is the most fascinating piece of it. I also am heartened by their First Amendment position of late, which seems to be pretty robustly trying to hold the government's feet to the fire on First Amendment issues, and I think we saw that last term and in previous terms, so I expect that to continue and look forward to that continuing.
Great. Neil?
Well, first of all, thank you. It's a real delight to be back with all of you again. Really treasure these discussions. I think my bottom line on the term is this is a term for the court to get back to law and to being lawyers. And any of you who've read Jan's amazing book, Supreme Conflict, I mean, that book really details.
I'll take that up with you. Thanks.
That book details really what Alito and Roberts were like as lawyers, and that is a trend that we've been seeing with appointments to the court. And sometimes that gets obscured a bit when you're dealing with health care and affirmative action and voting rights and gay rights and all of these big hot social button issues. But this is a court that really does profoundly care about law and getting it right. And I think this term gives them an opportunity to do so and to give guidance to industry, to other litigants, public interest groups out there who are trying to understand what is the actual law, how do we deal with this, and just to briefly mention something I'll talk about when we get to my term, patents. So the court yesterday granted 2 petitions. They were my cert petitions in the patent area, and industry, I think, particularly the technology industry, is really suffering under really vexatious litigation. And these cases give the court an opportunity to rein some of that in. And so I think from the business community's perspective, more generally, not just in this area, but in preemption and other areas, this is a term that I think is going to give us a lot of certainty in areas.
Thanks. So I'm delighted to be here. Thank you. I'll just add a little, I agree with everything that my co-panelists have said. I'll just add a little note of caution about it. I think one should be really hesitant about trying to impose a theme on the term. No one is up there deciding, let's have this be the business law term, or the First Amendment term, or the separation of powers term, or anything like that. It just doesn't work that way, right? So they get 8,000 petitions per year, and they choose 80 cases, but there is nobody up there who is in the business of trying to decide on the theme for the term. It's possible ex post that, that you can discover a bit of a pattern, but it is absolutely not deliberate on their part. Now, so all that said, I agree with everything my co-panelists said, and particularly Mike, who gave a little preview of my cases. I would say by coincidence, it turns out that there are these 3 cases that are about horizontal separation of powers. So there's a case about the scope of congressional power, a case about the scope of executive power, a case about the scope of judicial power, and so these are kind of fundamental structure of government cases, and that's a bit unusual. It's a bit unusual to have 3 such cases in one term, and I'll be talking about those 3.
All right. You guys ready to get started? And the record should reflect that Nick did resist my efforts to get them to express what they may see as a theme. So thank you for being a cautious lawyer today. We appreciate it. We're going to start with Mike. He's going to analyze 3 cases. Schuette, which is a Michigan affirmative action case, of course, Mount Holly, as he said, and Unite here. We're going to go in order of those and have a little discussion after each. The first one, I think, is potentially another one of those kind of, it's going to get a lot of coverage. It's a hugely hot button issue, affirmative action. The court's been moving in a certain direction. It involves a Michigan constitutional amendment that, on its face prohibits discrimination. And it turns on something that I've never heard of, I have to admit, the political restructuring doctrine. Maybe I wasn't paying attention in law school, that class. But Mike, tell us about this. And I guess my question is the court going to rule narrowly? What do you think?
Oh, no. I mean, in keeping with the understated point, the Sixth Circuit's decision was one of the most lawless, incomprehensible, and absurd decisions that has ever emerged from a court of appeals.
All right, you guys got that? Lawless, incomprehensible, and absurd. And I think Mike actually has a cert petition pending from the Sixth Circuit on a different case.
Yeah, well, they don't like me anyway. So, no, I mean, really. As Jan points out, Michigan says the government is no longer going to discriminate against its citizens on the basis of skin color because it's been 60 years since the Civil Rights Act, 60 years since Brown v. Board of Education, 50 years since the Civil Rights Act. Maybe we should stop discriminating on the basis of skin color. The Sixth Circuit said Michigan can't stop discriminating. Why? Because of the 14th Amendment. The 14th Amendment says that states can't racially discriminate against their citizens, and the Sixth Circuit interpreted the 14th Amendment to say you can't stop discriminating against your citizens on the basis. To the non-legal mind, this may not be straightforward. And as Jan points out, they came up with this political restructuring doctrine, which admittedly is embodied in an almost as idiotic opinion by Harry Blackman from the early 80s and the Seattle busing case.
And it's only been used twice, right, in the court.
It's clearly been the redheaded stepchild of
go
precedents.
Easy on the redhead.
Exactly.
That offends me here.
They didn't even cite it in the Romer case, which involved similar issues, even though it had been the basis of the decision below. Because what does this decision say? It says you can't decide racial issues in state constitutional provisions. Why? Because that means you can't lobby municipalities to get a different result than is embodied in state constitutions, which means if a state enacts an equal protection clause, that's unconstitutional because I can no longer lobby my municipality to discriminate on the basis of gay marriage or to discriminate on the basis of race.
It's another burden. It's more burdensome.
Well, if this theory was true, of course, that means a state can't decide any issue because every time a state decides an issue, it prevents you from seeking a contrary result from an inferior level of government. It also means Title VII of the 1964 Civil Rights Act is unconstitutional because it prevented you from lobbying state governments, an inferior government, to come to a different result than that is embodied in it. And it means, therefore, that every decision made in America, with the possible exception of foreign policy, has to be decided at the municipal level, because if it's decided at a higher level, you've been denied this ability to lobby. I don't think the court's going to buy it. First of all, Seattle has a footnote in it saying, of course, this wouldn't apply to affirmative action. Second of all, Seattle says this is about preventing racial discrimination, not as Michigan was trying to do. Seattle was talking about laws that fostered racial discrimination, whereas Michigan's law prevented racial discrimination. I litigated the Prop 209 case in California where they made exactly the same argument, and even the Ninth Circuit agreed that this was perfectly okay under Seattle, and cert was denied there. So I think this has a shelf life of 12 minutes in front of the court. I think the only interesting question are twofold. One is whether it'll be unanimous. Obviously, 4 members of the court have gone a long way towards upholding voluntary affirmative action programs. In other words, they say states are permitted to engage in some forms of racial preferences that benefit minorities. I don't think they'll step up to the plate on the much more ridiculous doctrine that the state is somehow required to engage in this sort of racial preference. And that also raises the question of whether they'll simply, in keeping with what Megan was saying a minute ago, whether they'll simply limit Seattle to its facts or overturn it. I don't believe Michigan's asked them to overturn it, but that could be one issue.
My guess is some of our panelists might have a different approach on this case. Neil, is this how
I actually
you would
don't.
analyze
I
it?
mean,
You
I
agree?
love disagreeing with Mike, and in fact, it's my bread and butter. But on this one, I think he's absolutely right. I mean, this is an indefensible decision by the Sixth Circuit. Now, the Sixth Circuit has had a remarkable track record at the Supreme Court. I think they've had 26 cases granted for certiorari of the last 5 years. They've lost 25 of them. And in its decisions like this, which frankly, explain why. I mean, reasonable minds can differ about whether or not affirmative action, is something that is constitutionally permissible. But the claim here by the plaintiffs that it's constitutionally compelled is, I think, I can't really imagine a justice going along with it.
But if the court were to strike down the Sixth Circuit, I mean, could you see the impact of this case being that other states would then look to pass similar constitutional amendments? I mean, is this a way that you could really rein in some of the voluntary affirmative action programs?
Well, sure, in the way that the Constitution and the legislative process are where it should be. I mean, it's perfectly appropriate to have constitutional amendments or legislatures doing this. That's what the debate should be. It shouldn't be courts imposing their views. Certainly not to have it. In my view, also the other direction as well. That this is really a legislative choice, and it's up to the people to decide, not up to the courts.
Any of our panelists want to weigh in on that one? Mike, counterpoint? No? All right, let's go on to Mount Holly. This is a case from New Jersey. Mike mentioned this in his opening remarks, a disparate impact case under the Fair, wait, am I getting that right? Yeah, under the Fair Housing Act.
So I'll get Neil to disagree on this one.
All right, you're going to have to amp it up a little.
This involves a so-called effects test, as Jan said, under Fair Housing Act. Does the Fair Housing Act prohibit things that are purposefully discriminatory, where you treat people differently because of their race, or does it prohibit things, even if you haven't paid any attention to race, which have a disparate statistical impact on racial or ethnic minorities? This is an issue that the Justice Department and this administration has been desperately seeking to have the Supreme Court not decide, which led famously, I think, to the Assistant Attorney General cutting a deal with St. Paul to try and get this case out from under the Supreme Court, because the Justice Department suspects, I think quite correctly, that their view in support of this disparate impact theory will be struck down.
And the facts of this are really interesting too. I mean, it's just a pretty, it's a neighborhood in New Jersey that had become blighted, right? And they wanted to demolish some of the
Yeah, I think to really understand this, and I'm not going to get into a lot of detail, but to understand You could argue that the effects test, the thing I just described, makes some sense in the employment context. If a test disproportionately excludes minorities, we want to make sure the test is job-related, and that will help the employer, right? Because he'll get better qualified employees. One of the problems in applying the effects test in the fair housing context is it literally makes no sense and puts dramatic handcuffs on both municipalities, landlords, and banks. And so, as Jan just pointed out, Mount Holly is a perfect example. It's a racially diverse community. I think it's 22% black and about 10% Hispanic. Not very small, not especially wealthy, but there was this one area of town which had very high crime. It was terrible housing, and they wanted to say, look, this is a blighted area. Let's improve the housing that we've got there. So they went through this urban renewal process, which would make the houses better and more secure and safe for their people. But since the houses were better and it was more expensive, and therefore the plaintiffs came in and said, minorities are disproportionately poorer than non-minorities, therefore you are limiting our access to the new improved housing. So you either can't ever, urban renewal was their point one, or their point two is if you do, you've literally got to pay every minority tenant, no non-minority resident. You've got to exclusively give a racial preference to them and compensate them for this. So as that illustrates, really what the effects test would be in this context is either a quota in terms of whatever amount of minority housing you've got currently in your town you can never diminish, or it's a straightforward racial preference. If you do diminish it in any way, you've got to preferentially compensate only one race. The other context it would come up in is normal landlord. I mean, every time a landlord raises his rent, it has a disparate impact on minorities because disproportionately minorities are not as wealthy as non-minorities and therefore can't pay it. Every time a bank makes a loan, if it does it on the basis of neutral credit worthiness, it has a disproportionate impact on minorities, which was one of the things that HUD had vigorously opposed, particularly in the Clinton administration, but continuing through the Bush administration, and was one of the reasons we had the housing crisis, is they kept insisting that banks make loans to borrowers that were not creditworthy because of their minority status. So none of this would make a whole lot of sense. We do have the Griggs decision out there in the employment context. The people arguing in favor of Mount Holly are pointing out the language differences between Title VII and Title VIII, the gist of which is it says you can't refuse or make unavailable or deny housing or housing financing because of race. That means, of course, because of race. It doesn't mean because of things that are statistically correlated with race, and because it would operate, as I say, as both a de facto quota and a de facto preference for racial minorities, which raises serious constitutional questions. I think the one unclear aspect of all of this is Justice Scalia's behaved in a quasi-schizophrenic mode in this area. The good Justice Scalia has pointed out that the effects test is a de facto quota, raises very serious constitutional questions, and as he said in the Title VII context, is a powerful engine of discrimination. But then there was this case called Smith versus City of Jackson, which again, not coincidentally, I litigated. And in the age context, where Justice Scalia, wearing his badge Chevron deference hat, upheld a reg that turned a discriminatory purpose statute into a discriminatory effect statute, and he said that was okay in the ADA context. So
let me ask you, I mean, we like to think of Justice Kennedy as kind of being that, human jump ball who, we don't really know where he's going to fall. But in this one, I mean, you think this could turn on Scalia? The fifth vote.
Well, again, it's Scalia's common sense and understanding of the 14th Amendment, or will it be Chevron uber alles? My own view is that since this will focus directly on the consequences of interpreting an effects test in this context, the good Justice Scalia will emerge. Justice Kennedy has been, if in any area, I think, both in the voting rights context, he understands intuitively and has articulated that these effects tests and that these statistical measures of discrimination are just mechanisms for, in the redistricting or other contexts, just mechanisms for divvying us up by race, and he has not been very supportive of
Right. I
those.
mean, say what you will about Justice Kennedy on affirmative action and race cases. He's been a solid vote with the conservatives, as well as on First Amendment, I think. Neil, I know you wanted. Mike has promised that you're going to take a different issue, and my guess is that you will.
No, the truth is I'm not all that familiar with the case. It's a little hard for me, but I guess I would react on an institutional level to a couple of things that Mike is saying. I mean, it is interesting that in the discussion he's focusing on agency regulations and switches in administration position and so on. This is Title VII. It's a federal statute, and from an institutional perspective, it does seem to me a lot of these debates really do, and this goes back to what I was saying before, should be tossed in the legislature. I mean, we should have, if we really believe in an effects test, I think it should be enshrined in the U.S. Code, or if we don't, it should be, prohibited in the code. But, I mean, right now, so much of this stuff gets thrown to the courts or to the agencies or some bureaucrat in the agencies to come up with one way or another, and I think that's a profoundly bad thing for our democracy. And so I think cases like this, before they get to the courts, should be hashed out through the legislative process.
Yeah, and the
So let me
legislature, they
just-
really seem to like that, don't they, Congress? When
no,
the
but-
court punts over there to them. No.
No, I actually want to agree with Neil. I mean, look, this law was passed in 1968. Everyone thought naively that refusing somebody housing because of race meant you can't refuse them because of race. It didn't mean that agencies were now going to tell you how to engage in lending practices and urban renewal. You can't look at the legislative history. People like Fritz Mondale were saying, look, everybody gets to make the same decision. They just can't use race as a factor. You go from that completely non-controversial basic moral principle to something which is very different, and I fully embrace what Neil just said. Those kinds of profound shifts in what a non-discrimination law says should be done by the legislature, not by an agency. And I'll point out that it is rife with politics. In 1988, my Reagan Justice Department said Title VIII was an intent to test, and then now this administration is saying it's an effects test. So it is the kind of thing that I don't think you should leave up to shifting administrations and a bunch of GS-12s at HUD. But that's just me. So.
And Congress is.
Yeah,
So
of course, Congress really
eager
wants
to
to.
jump into-
Jan's making the point sarcastically, but truly, which is one of the problems in American society, is Congress issues these grand pronouncements and then does, either surreptitiously or otherwise, delegate all the tough decisions to the agencies, and I think that's very bad for democracy as well.
And I think they rely sometimes on the courts.
Yeah.
I mean, they look to the courts to make the hard decisions so that they don't have to. And I think that's an interesting question, seeing in the Roberts Court is they're saying, we're not, Congress, you have to do your job.
Right.
But at any rate. All right, the last case that Mike's going to tackle, he'll, of course, be involved in the discussion. And I know, Neil, you're going to weigh in on this one as well, is the labor union case. And it's kind of a weird case, but whether or not employers can give something or offer some assistance to labor unions in exchange for them agreeing not to go on strike or supporting something that the employer wants to do, whether that's illegal or that's some kind of a thing of value. Mike?
Right. It's called the Unite Here case, and as Jan correctly pointed out, Section 302 of what we typically call the Taft-Hartley Act says that employers can't pay, lend, or deliver a thing of value for either a union that represents or seeks to represent their workers. The obvious point of this law was not to allow them to either corruptly bribe unions to be true to employers or to have an arrangement where the union's representation is affected by external gratuities or other things by employers. So that's relatively straightforward. The tricky part is there's relatively not a typical practice under the NLRA where unions and employers will come together prior to the union being certified, will they sort of make a deal. And the employer, like in this case, says, look, I'll allow you to win representation through card check. For those of you not, that in the labor world, that means if you get a majority of people checking a card that they want a union, I won't make you go through an NLRB election where we really play this out. I'll give you a list, names of addresses of all my employees. You can come on my property, talk to them, and I'll be neutral as to whether or not they should unionize. In exchange, in this case, which is, again, relatively typical. The union says, look, if we do have a collective bargaining agreement, we won't strike and we won't picket you if we come to it. I think the very atypical part of this, although I don't know, I'd be interested in Neil's view, they also said the employer in this case was a casino or wanted slots, a slot machine, and there was an initiative to allow them to have slot machines, and the union promised to give $100,000 to get this initiative that was going to help the employers. So if you exclude out that slot machine thing, the basic question is this sort of typical arrangement between employers and unions something that is really conveying a thing of value in a way that we care about in terms of corrupting what the union is doing? I don't know where the court's going to go on this. I mean, from a plain language perspective, they're clearly giving them things of value, but was Congress really contemplating that these things that are inherently involved in labor management relationships are the kinds of things they were talking about that? There's a number of complications in terms of the way the case is presented. I'll just briefly touch on. The 11th Circuit was deciding this in a motion to dismiss context. And the 11th Circuit's opinion was pretty narrow. It said, look, we're not going to dismiss this. There may be a set of circumstances in this context in which you could establish that there was valuable consideration going back and forth, and that somehow corruptly influenced the union. So they could write a relatively narrow opinion. The interesting thing is, I can't remember which circuit, but it was a few years ago where there's a similar law in terms of you can't give anybody a thing of value in terms of plea bargaining. And they applied that literal excuse me.
The 10th, yeah.
It was the 10th, right? And
Crazy
they said,
decision.
look, if you give somebody a plea bargain, you're giving them something of value. So plea bargains are not legal. No one took that very seriously because it would have brought the criminal justice system crashing to the ground. This is not all that different, although I don't know really what the consequences would be for the labor movement. But again, the administration is on the side of saying this arrangement is proper. I have a tough time predicting how this will come out, but it is sort of, again, an interesting thing for people who are interested in law in terms of literal application of statutory language versus, what Justice Breyer would call consequences and the underlying policy objectives of Congress.
God, I feel like I'm being so boring, but I'm actually going to agree again with much of what Mike said. So I mean, and if that's a kind of precursor to the term, maybe we'll have more unanimity and we'll finally get to Chief Justice Roberts' promise at his confirmation hearings to have more unanimous opinions. I mean, last term I think the court was unanimous 41% of the time, and 49% of the time, and 41% over the entire tenure of the Roberts Court. Might be that we have a higher percentage this year. I think Mike describes the case fairly. I'm somewhat involved in the case, just to disclose that. Bill Messenger, the chief counsel for one of the parties, is here and can, I think, answer the questions better than I can. But I think that the question about what is a thing of value is a hard one. The government, the United States Solicitor General, takes the view in this case that that there isn't a thing of value being promised here. That's not the ordinary meaning of the word. But in other contexts, the Justice Department does have a much more expansive view of what things of value include. And so I do think I expect some tough questions for the government in this case, and I do think that the challengers to this agreement have a pretty powerful case.
Let me ask, though, just kind of stepping back. I mean, what's the significance of that? I mean, why should we care about that? You said, I mean, it could come up in other contexts, of course, but why should we watch this case?
Oh,
Anybody?
me.
Anyone?
I
mean, other than it involves like slot machines and the facts are interesting. But
Yeah.
what potential significance could it have?
Okay.
And just say something.
Right.
Come up with something, Mike.
Yeah, well, the sum total of my knowledge is talking to two labor lawyer partners of mine at the law firm who tell me that these are relatively routine and it could have a profound effect on how, particularly in certain industries that are looking for relatively frictionless kind of representation, it could throw a complete monkey wrench into that. So what you would make is almost mandate more hostility between employers and unions when unions are trying to organize.
So more difficult for unions
Yeah,
potentially.
and the question of how many
organize.
people are really in a frictionless environment these days, right? Because employers are generally resistant to these sorts of things. And then I think the point Neil alluded to, the U.S. Code is larded with the word things of value. Obviously, bribery, public corruption, all of these kinds of cases where the government takes an extraordinarily expansive view of things of value, now they've sort of shifted position and say things that are clearly cognizably valuable in any real sense need to be much more narrowly construed. And so it will be an interesting way to write the opinion, whether they look on the words things of value and say things of value means things of value, that's it. Conversely, if they say, well, no, you have to really understand the context and stuff, that might have some blowback and hurt the government when they're trying to push the envelope in terms of public corruption in other cases.
All right. Well, thanks. We're going to move on now to Mary Beth, and again, we want you to weigh in on these other discussions too. Mary Beth is going to summarize the EPA cases, some potentially significant environmental cases, and one that may be looming, if you want to just mention that briefly, and then a couple criminal cases too.
Yeah, I think I'm going to start with the lighter ones first, the criminal cases. I'm going to cover Fernandez versus California, which is a Fourth Amendment case, Cayley versus United States, which is a Fifth and Sixth Amendment case, and then on to the dual environmental cases, which have been consolidated for argument, I believe, coming up soon in this term. And that case, of course, is a lot more complex than the criminal cases. I'm going to start with the criminal cases.
And these are always, just to interrupt, the criminal cases, as you guys know, they're always like the ones where people go like, really? The court? And these both have great facts. I mean, you're going to do Fernandez first?
Yes.
I mean, that's a couple is trying to hire a lawyer who's pretty expensive.
Cayley.
Okay, you do
Wait,
Cayley.
no,
Okay, so
Fernandez first.
you do the roommate one first? Okay. Oh, this one's even better. We're doing the first. This one's awesome. So, you got a roommate, and somebody, you say, no, you can't search my apartment. And so then the police haul you off to jail, and then your roommate says, okay, go ahead. So can the co-occupant give consent? So that's the first one.
Yeah, Fernandez deals with what is called the co-occupant consent rule. And it had been pretty standard, in the law, that if you are a co-tenant with someone, you can give consent because you're sharing the tenancy. But in Georgia, or Randolph versus Georgia, the court, for the first time, said that when you have two co-tenants, one tenant can object to the search of the premises, and so the consenting tenant is then overruled by the non-consenting tenant. So this came out in play in the Fernandez case. In Fernandez, the police were looking for someone who fit the description of a man who had assaulted and robbed someone in a nearby alley. They follow him into an apartment, and as they're nearing the apartment, they hear screaming and things are breaking, and so they go in and they find a woman who's got blood on her clothing, and she's clearly been in a fight. And a man comes out in his shorts, he's sweating, he's very agitated, and he immediately says that he knows his rights, and he tells the police that they cannot search. And as it turns out, these two are co-tenants. The woman is the girlfriend of Fernandez and the mother of one of his children. And the police, suspecting this is domestic violence, they take Fernandez out, separate them, and then they begin to question the woman and the child, and eventually they spot a tattoo on his head, and they put everything together, and they realize he's probably the guy that assaulted someone in the alley, so they take him away, do a field show up. He's identified as the assaulter, and then he's arrested. So the police go back and they get the consent of the girlfriend to search the premises, and they find guns and knives and other things. And he's then charged with assault and robbery and possession of an illegal weapon. Later, there's some discussion in the trial court about whether that consent was actually voluntary, but that's not really the issue in this case. Fernandez is convicted. He goes to the California Court of Appeals. The conviction is upheld. He then appeals to the U.S. Supreme Court, and he relies on this Georgia versus Randolph case in which the Supreme Court, in a 5-3 decision, said that a co-tenant can object, and that consent is no longer valid. But it did leave an exception for not being able to take someone out in order to avoid their consent. Where in this case, Fernandez originally objected, but then after he was arrested, he was no longer present, and so his objection was no longer valid. So the court is going to be deciding this issue. And what's really interesting when you look at the Randolph case, when it was originally decided, this was a decision by Justice Breyer, Souter, Ginsburg, Kennedy, and Stevens. And Stevens wrote the opinion, and Justice Breyer wrote a concurrence. We had dissents from Justice Roberts, Scalia, and Thomas. So when I originally looked at this, I thought that this may be another one of those decisions in which Justice Scalia is going to support Fourth Amendment rights and say the police should have gotten a search warrant, and this is not an excuse for going in and getting consent. But upon a more careful review and a review of Randolph, I can see that that's not it at all. I think the court is going to go back and revisit the decision in Randolph, because in Randolph, the court really relied on some social norms about when you have people in a social situation and one of them invites you over and the other one objects to you coming in, would you, in a normal situation, would you enter when one of the co-tenants objects? And Justice Roberts really wrote a very strong dissent that says that's not really the way to look at the Fourth Amendment. You're supposed to look at whether, what are the expectations of privacy. And when you share a residence with someone, you lose that expectation. And so it really shouldn't matter. You shouldn't be focusing on the person's objection. You should look at whether the person who does give consent has the ability to do so. And interesting, Justice Breyer, in his concurrence in that decision, specifically said that the court's opinion wouldn't apply if the objector is no longer present. So I think in this case, when we have Fernandez under arrest and no longer a valid objection, the court is going to relook at this decision. They're either going to uphold it, or they're going to go back and say this rule that we established in Randolph is really not workable, because depending on what the circumstances are, if you object, what if you go out to answer the phone? What if you go out to get coffee? Do you have to remain and continue your objection? So it's really not a workable rule. So I predict either upholding the decision or going back and rewriting.
So Mr. Fernandez is not.
Yeah, I think he'll be in jail for 14 years.
All right. Anyone else? Anyone want to weigh in on that one?
I think his relationship with his girlfriend's probably gone anyway, so I don't know. I don't know that the separation.
All right, the next one is Kaylee, and Kaylee, yeah. I don't know why I'm struggling with these. This was I'm just going to briefly say the facts, and then you could just maybe get to the issue. I mean, the government froze a couple's assets, and they'd wanted to use that. It was about $500,000, I think, in a home equity loan, to pay for the lawyer of their choice. And what's the main issue here, and what do you think the significance of this case is, Mary Beth?
Well, this is a case that I think we can all look at the Kayleys and sort of envision someone that we know possibly being in the circumstances. In terms of looking at a forfeiture case and looking at the facts of the case and seeing the court do something different with forfeiture law, there's probably not a worse set of facts than Kaylee. And just to briefly tell you what happened, this husband and wife, she's in the medical device business, and she's accused of stealing and selling medical devices that hospitals don't want. No one's claiming to have been wronged by it, and she's under investigation for 2 years. So is her husband. They realize they're going to need assets for their defense, so they take out a second mortgage on their home and borrow $500,000, and then they put that in a CD for 2 years so they can continue to gain interest while this investigation is pending. Investigation goes on for 2 years. They're indicted, and their assets are seized. So they want to go to the court and have a post-indictment, post-seizure evidentiary hearing. And the magistrate initially denies this request, saying that the assets were properly frozen. They appeal to the district court. The district court agrees with the Kayleys and says, yes, you are entitled to a post-indictment, post-seizure hearing. But the question is, what was that hearing going to be limited to? And the district court it gave them an opportunity to present evidence, and instead of challenging whether the assets were connected to the crime, they wanted to challenge the probable cause of the underlying indictment. And they lost again at the district court. They took an interlocutory appeal to the 11th Circuit, and the 11th Circuit affirmed. So I think Now what's before the court, you have a number of circuits that all hold that individuals are entitled to some type of or some type of post-seizure, post-indictment hearing, but the extent of that really is unclear. So some circuits, the Second Circuit and one other, will allow some type of limited evidentiary hearing on the probable cause issue, but the other circuits have not allowed defendants to get into that.
So what's your sense? I mean, what do you think the potential significance of this one is? How often is this?
Well, I think that this issue occurs very, very frequently. Normally what happens in practice when defendants have extensive assets, the government certainly wants to go in and seize those and freeze those so that they are available for forfeiture or restitution, and you know, that has been upheld. The forfeiture provisions have been upheld under that basis. They've also been upheld even when those funds are to be used for counsel. So the Cayleys are arguing that they didn't have the right to use those funds for the counsel of their choice, and the court disagreed and said, you know, you haven't been able to show that you can't get counsel, and you can't attack the underlying probable cause for the indictment. So I think that what the court will use this case for is to clarify the procedures for challenging a seizure, for challenging this, you know, post-indictment, and sort of set the process so that it will be followed consistently among the circuits. Is when you think about this nightmare that really, you know, this investigation went on for a while, all of these post-indictment proceedings went on, and the Cayleys have probably spent more than $500,000 and they haven't even got to the trial yet. So this really is an issue that there should be some consistency among the circuits. But I think what the Cayleys want here is to be able to challenge the probable cause of the indictment, and that's just not workable.
So the court, I mean, it would be welcome to have some kind of clearer rules on this, but maybe this is not the right case. Or
Yeah,
potentially.
I think that it is the right case to clarify the rules for the procedural post-indictment seizure. I think it is the right case for that. I don't think that the court is going to go as far as the Cayleys would like them to and allow them to challenge probable cause, because, as you can imagine, when the grand jury returns an indictment, that is a finding of probable cause, and so you can't have. Now I'm putting on my former prosecutor hat. You can't have, you know, a mini trial before the trial, and you know, if the court can take away liberty and keep defendants in custody pre-trial, you know, then I think they're going to be able to keep their assets as well. So the court won't go as far as the Cayleys want them to, but I do think that we will get some more clear provisions with respect to forfeiture.
All right, let's move on to the EPA cases, because we're.
No one is going to disagree with me on this?
I'm just trying to keep this moving.
Okay.
I'm like, oh my gosh, Neil has to leave it too. So we're going to try to. Although, wait, does anybody really want to jump in and disagree? No, Mike, come on.
At a high level of generality, I think these asset forfeiture procedures by the government are very threatening to liberty and need a lot more restrictions. And I don't understand why a grand jury indictment is enough to seize somebody's property, particularly since, as the saying goes, you can indict a ham sandwich. So I think it's very dangerous, and I would think that there would be at least one level of due process protection beyond the indictment for the before you can seize their property. The government wants to prosecute them, prosecute them. How do they get their money before trial seems to me an entirely different question.
All right, well, on to the environmental cases. Did you want to say anything, Jan?
No, go
Okay,
ahead.
all
I
right.
mean, one is
now-
the transport rule. It's kind of a complex case, but if you
Yeah,
want to just
what-
briefly say
all
why
right,
it's significant.
What I'm going to do here with these environmental cases, these are really, really complicated. And so first, if there's any environmental specialists in the audience, I apologize for oversimplifying this. But I had to simplify it in a way that a criminal lawyer could understand it. So that's what I'm going to try to do. All right, in these two environmental cases, we're looking at sort of the balance between the EPA's authority to regulate air quality and the state's authority to set environmental regulations. The EPA establishes air quality standards, and so that is sort of the overall, you know, job of the EPA. But it is left to the states, again, to set individual regulations within its state, within its industry, to try to comply and to meet those standards. In trying to do this, I think this case really vividly shows how impossible it really is to accomplish both of these things, because the EPA regulations are so complicated that they're not only regulating individual states, but they're regulating how the the pollution of individual states upwind affect states downwind. So they've essentially identified 28 states that emit the most, and that's probably because they're states that have power generation and things like that. And so they set the air quality standards, and then these states have to develop state implementation rules that are going to show how those states are able to comply with the EPA regulation and to take into effect how their emissions are going to contribute significantly to the other states and particularly to those downwind. But this term contribute significantly was never really defined. And so the EPA has established these rules, and then the state goes out and develops its implementation policies, and then the EPA can come back and say, no, we don't agree. And then they can establish their own set of rules if they want to. And states really didn't have sort of the warning of what the EPA was going to do and how they were going to define that term. So there are two companion cases. There is EPA versus EME Homer City and American Lung Association versus EME Homer City. And these cases end up in the DC Circuit, and the circuit really takes a very narrow, well, not a narrow view, but they totally disapprove of what the EPA has done. And they've said that the EPA has done this incorrectly. They haven't properly defined what significantly contribute means. Their method of doing so is not workable, and they essentially establish their own sort of mechanism for how this is to be done. And this is a very, very strong opinion, both from the majority, which is written by Judge Brett Kavanaugh, as well as the dissent, which is written by Judge Janice Rogers Brown. And I really think that the central issue here really goes to the heart of this question of what is significantly contribute, and what the court is going to have to look at this. The court is first going to look at this from a jurisdictional standpoint, because in this case, the EPA promulgated these rules. They never defined significantly contribute. No one complained during the public comment period. There was no administrative review, no exhaustion of the rulemaking policy. And then, that this case goes to the circuit, and the court then puts in, its own scheme. So before the court, the court is going to have to look at this question and determine whether it even has jurisdiction for it. It's going to look at the circuit court and whether it really disregarded the prior precedents of the DC Circuit.
What's your prediction?
My prediction is that the court is simply going to say that they do not have jurisdiction in this case. They're going to send it back. They're going to have administrative exhaustion and allow that to take place, because that seems to be.
So they may punt on that one. There's another one though. I know you were going to talk about, or you want to talk about the cert petition, the greenhouse gases. Are you going to do that one? Okay.
We agreed 15 seconds on that, so I'm prepared to do that. So
we want to have the discussion. Why don't we move on and we can discuss both of those then together at the end? Do you want to do that? Sure. Does that work? Okay. Mm-hmm. Anything else you want to add on that one, or does anyone want to?
Well, I mean, it's. I think that in order to properly look at the methodology, it's helpful when you can look at the administrative proceedings. And in this case, it just didn't occur because the administrative process wasn't exhausted. And I never thought I'd hear myself sitting here talking about why administrative exhaustion is just so important. But I think this is really one of those cases where if that had occurred, then the court would have something to look at and something to review.
But probably won't. But may not. Okay. All right. Well, thanks so much. Then we can circle back. I think maybe at the end, after we go through the panel, we can come back to that on the cert petitions. We're going to move on now to Megan, who is going to tackle 3 of the cases you're going to be hearing a lot about, and that will get a lot of attention, certainly in my business. One involves campaign contributions, one is abortion protests, and the other is legislative prayer. So Megan's got
All right.
some. Mike, I'm surprised you. I know you'll have something to say, Mike. So why don't we start with McCutcheon first? I mean, that, everyone knows there's caps on what you can contribute, to individuals, to committees. This is overall the aggregate cap overall, the amount total that you can spend. That's the question in this case. Obviously, campaign finance, very controversial. Is this going to be another Citizen United? Is this going to what's your take on this one?
I mean, I think it does involve aggregate limits. It's sort of a pretty esoteric area of the campaign finance world about which many people in this town care very, very intensely. And a lot of people in the country don't, other than they see headlines and they see President Obama at the State of the Union criticize the Supreme Court. And so they got that buzz, but I don't think many people really understood it. In all candor, I'm going to lay a little marker around this discussion. I'm not going to try and get into the weeds of the 441B discussion about whether the anti-circumvention rationale is real. The parties debate that. You can read those briefs.
And I think what
it's
people
tough.
care is that let's talk about,
Yeah.
kind of the court, how they've looked at campaign finance and what this may mean in terms of how they're approaching some of these cases.
Yeah, the commentary on the case is, I think some of it's trying to tee it up as a Citizens United because people do fear that Buckley versus Vallejo, this sort of bedrock campaign finance decision from the 1970s, may be in some danger based on the march of cases over the past few cycles where the court has been pretty First Amendment protective and been pretty willing to strike down some campaign finance restrictions. Buckley, to recap, differentially treated expenditure limits and contribution limits. Most of the cases to date have been seemingly on the expenditure side. This is a contribution limit case. What's going on is Sean McCutcheon here and the RNC have challenged this aggregate contribution, which is at about 120 grand. The RNC and McCutcheon argue that this contribution limit should be subject to strict scrutiny, and really that it's just unnecessary because campaign finance law has evolved such that the things that animated the permissible laxer scrutiny of aggregate contribution limits in the past don't really exist anymore. The government has...
In other words, it's a different world.
It's
so
a different
many
world.
more
BICRA
caps.
came in. They've sort of closed some of the loopholes that animated the Buckley court's willingness to indulge this aggregate limit. And I will say, for purposes of understanding the stare decisis point that will come up, the Buckley court did address this kind of aggregate cap, but in a very short piece of their opinion that the court said was not separately briefed at length. So I think the real question is, on the first order question, do aggregate contribution limits fall? If I was a betting person, I'd say they probably do in this case, given the march of time, although those expenditure cases don't exactly map onto this. We're in a bit of a new world on this contribution, on this aggregate contribution side. I think they will have to distinguish or repudiate that little portion of Buckley that dealt with this seemingly quite narrow piece of campaign finance marginalia, but they have been asked by amici to overrule Buckley if they are so inclined. I think there is an appetite among many justices to do that, but I think this case will really put to the test that question of how far are they willing to go? Are the Chief and Justice Alito willing to take out Buckley?
Which they were unwilling to do.
Yeah, I mean,
in the
Buckley's
past.
been cited many times. It's a foundational campaign finance law that lots of people can agree lots of people can argue is misguided, and a lot of people argue in the amicus briefs, get rid of this artificial distinction. Contributions and expenditures are flip sides of the same coin. I don't see them being willing to do that at this point, but that's a bit of a gamble.
Let's ask the
very well
panel.
could.
Does anyone see this being kind of a big, sweeping, let's walk away from Buckley kind of case? Or is this something that could be just, they're going to do this one narrowly too?
Yeah, I mean, they didn't take this case to affirm it, so I think they're going to uphold these things. But the rationale on the cap makes no sense, right? If I can give 10 $2,500 contributions without corrupting anybody, what difference does it make if I make 100 $2,500 contributions?
So that's out, you think? That's
So I think
clear.
it's out.
They're going to strike down these aggregate caps.
So I don't really see any opportunity here or necessarily appetite to throw out the whole distinction between contributions and expenditures. Justice Kennedy's expressed some displeasure with the distinction in the past, but I think everybody will wait for a case my guess would be where it's more squarely presented.
I mean, they could lay the foundation for that. They could continue to express frustration and then 2 or 3 years out do that. I also don't think it's going to have an enormous real-world impact. I mean, people get very excited about these cases in certain groups, but it does affect an incredibly small universe of people who are at the point where they really want to give more than $120,000 across federal election cycles. I'm not in that group, and I sort of hope the contribution limits never go away so that
And
we
these are
always
people
have
who
that
are,
limit.
They're giving to, 18, they're giving the maximum, they want to give the maximum to 19 different candidates. I mean, it's not like there's this corrupting potential where someone's wanting to give $150,000 to one person. They just want to be able to spread the wealth to a bunch of.
I mean, they may want to, but they
Right,
can't.
but that's the issue. The issue is, I want to give to 25 different candidates, not 18.
It affects the parties too, because
Yeah.
the overall cap. But my friends in that world say it's going to affect like 25 people.
Yeah.
Okay, so
Seriously.
the lesson here is when you see all the breathless coverage about campaign finance in the Supreme Court and the sky's falling, our panelists saying this case, don't believe all the hype.
It'll be
Right,
just
that's
as
the bottom.
accurate as the coverage about citizens.
All right, let's move on then to one that this case, I think, you could see also a lot of people saying the abortion protest case. Let's do that one next, because this case, I think, which involves a buffer around reproductive health clinics and whether or not people have to kind of stay back, is one that could very well overturn a case from 2000, Hill versus Colorado, and my bet is they will overturn that case, and Justice Kennedy will write the opinion.
Yeah, just by way of brief background, Hill in 2000 approved Colorado's clinic access law, which established sort of an 8-foot buffer zone around people entering healthcare facilities. They took care to define the healthcare facilities broadly. The buffer zone was fairly narrow. Those things were important to the court in Hill in 2000, but they were not important enough to keep Justice Kennedy from writing a very, very strident dissent that
Which he read from the bench. I was in the courtroom that day, and his voice was shaking. He was so angry about what the court had done with Justice O'Connor and the Chief Justice and the majority upholding this, saying that, people couldn't even give them a little pamphlet.
Yeah, and so I really think Hill is in some danger here. The makeup of the court has changed. O'Connor and Rehnquist, who signed on there, weren't here. I think a lot of people think that Hill is sort of a constitutional anomaly. It seems to be in that bucket of abortion-related litigation that has its own set of jurisprudential principles that get applied to it that would not probably be applied if it was any other sort of context, and that's something that you see a lot of amicus briefs filed in this case in support of petitioner, including the ACLU and the AFL-CIO, who quite articulately explain that this sort of paradigm applied to other types of facilities. Query whether they would actually do that outside of the abortion context, but you can see it being rather pernicious because here they've set up a 35-foot zone in multi-directions from entrances, exits, and driveways. And I won't bore you with the details, but there's 3 clinics at issue in Massachusetts, and they have slightly different circumstances, but in a couple of them, this basically means that the protesters and counselors, and they take pains in briefs to make sure it's the 85-year-old grandma with the pamphlets, not sort of violent protesters, but they're basically shut out from the opportunity, which the record they have made shows is actually quite effective at their mission. So I think those factual distinguishments will be meaningful to Justice Kennedy, and with the change in the court, I think Hill probably goes down, and you return to a much more narrow approach that obtained prior to Hill. The court had 2 cases, Madsen and Schenck, that had approved injunctions against disruptive behavior and clinic access obstructions, and the court sustained those, but in reading those opinions, you can tell they were moved by the factual record of violence, threats, obstruction that is really not seemingly present in this Massachusetts case. And there's a bunch of other little interesting nuggets in the record here, but I think that really covers the landscape. It'll get a lot of attention. I know other states and localities are looking at similar laws. That's in the brief that Maine and I think Oregon are considering following the Massachusetts model. So people will be watching this.
Well, I think this will get a lot of attention. Obviously, abortion cases we always cover. I mean, those are huge cases for the media. It's also kind of an irresistible narrative if Hill goes down. The new Roberts Court, O'Connor gone, walking away from some of those. I think you're going to see a lot of that kind of narrative emerge. This case, the other case, This is also your case, if we could turn to that, is the legislative prayer case. And the court could, I don't know if they will, what do you think, again, take a different path than Justice O'Connor? Maybe create some new law in the
Yeah, again,
religious
this is it's
expression
called
and establishment issue.
Town of Greece versus Galloway. It's an establishment clause case. Lots of amici on behalf of the town, including the United States, that filed an amicus brief. It really involves a case from 1983 called Marsh versus Chambers that sustained a legislative prayer practice in Nebraska on a largely historical analysis that said legislative prayer has been done for 200 years. It's part of the fabric of the Constitution. It's not an establishment clause violation. I think some people think that's an odd analytical construct, and so you see criticism of that as being sort of a sui generis kind of approach to it that may be unsatisfying. But here, the town of Greece had a practice of convening its town board meetings using volunteer prayer givers that drew primarily from Christian congregations, in no small part because of the demographic makeup of the town of Greece. So these two residents sued. One claim is not relevant anymore, but one said the prayer practice advances a single faith in violation of one of the boundaries set by Marsh, that you can't use legislative prayer to proselytize or advance one particular faith. They lost in the district court, but the Second Circuit disagreed, and they applied a totality of the circumstances test and really went in and parsed the prayer language, the identities of the prayer givers. They have the map of where the congregations are, and the town appealed, arguing that this was improper. They should have stuck with Marsh, applied Marsh, not brought in this endorsement test, which was found principally in a 1989 creche case, the nativity cases, where they looked at it and applied an endorsement case. But now this will sound familiar. Justice Kennedy was in dissent in Allegheny saying this endorsement test is a terrible idea and we should apply Marsh in this case. So what you'll see before the court is a couple of dynamics. One is, does this prayer practice come sufficiently in Marsh that they can just say, Marsh applies, don't bring in this endorsement stuff from this other line of cases? Or, as they've sort of been invited to do in the briefing and certainly by amici, do they go further and really dump on the current Establishment Clause jurisprudence endorsement test?
And that would, of course, make this a quite significant case
and
involving
because
the Establishment Clause.
that's a doctrinal area that people are very dissatisfied with and have been calling for the court to clean up, because it has this sense of being very ad hoc, case-specific, and unpredictable. And
Right, what is a reasonable observer?
What is the reasonable observer, right? And that has been used to strike down various things. Thomas, Scalia, and Alito have all sought to fix that endorsement test, and they have dissented from denials of certiorari repeatedly. So the appetite may be there, but I think this is a question of whether they're willing to sort of reach out and go further towards Allegheny and endorsement, or just sort of apply Marsh and say the Second Circuit misstepped.
Let's throw that out to the panel. Anything you guys would like to weigh in on here in terms of the Establishment Clause, reasonable observer, Justice Kennedy, the absence of Justice O'Connor, the direction of the court, incrementalism? There's a bunch of different jumping off points for these cases.
Sort of wonder if the court will have to change its own introduction, God save this honorable court. I mean, that would affect, the Supreme Court really.
But according to the petitioners, ironically, they take a great issue, I should say, the respondents, they take issue with the presence of Christ in the town's prayers, which I think would save the court's invocation. So they might be able to slip through under the historical practice, the respondents' view of it.
Well, I think there's also a distinction too that in the practice in the the local town meeting, they're not really encouraging other people to participate. It's really just one person at a time offering something. So it's not really encouraging others. So.
Well, one thing that I found interesting in the briefing was the sort of pivot I saw towards coercion. In the complaint, they had talked about coercion. This prayer is coercive to children was really the allegation of the complaint, trying to grab onto Kennedy's special solicitude for children in school settings, for example. Now, at the Supreme Court stage, they have their brief reads quite heavily on adult coercion and a lot of things that have been spun out that I don't see in the record, but they're really trying to spin this coercion theory out, and I don't think the court's going to be very responsive to it, but that may indicate some weakness on the endorsement test part of it.
Look, the Establishment Clause jurisprudence over the past 30 years has been hardly a seamless web, right? It's been an ungodly mess. I mean, they...
Ungladly mess, guys. You got that?
He has all the good stuff.
There you go. So they abandoned the lemon test. I think there's two results. They just cite Marsh v. Chambers and say, we'll follow this historical practice and not get into it. I think they might well take a shot at endorsement, particularly because O'Connor's no longer there. Kennedy doesn't believe it. The respondent's brief was a straight coercion argument where they were trying to build on his Levy-Weissman argument involving a 10th, 12th high school graduation. I don't think they really were very persuasive in that, but even they, I think, recognize that the endorsement test may not be long for this world. And the entire area screams for some kind of coherent guidance. I don't know if we'll get it, but we might get some limited guidance.
Yeah, anyone else want to add on any of this? No? All right, well, let's move on to Neil, because I know you've got to leave shortly. And I know you've already weighed in on a couple of the cases, but Northwest versus Ginsburg and Kansas, are those the ones you're talking about? And Kansas v. Cheever, you ready with it? So Northwest versus Ginsburg, frequent flyer programs, and you can really get booted off your frequent flyer program.
Yeah.
I didn't know that. Did you guys? Yeah, apparently. Anyway, and the Airline Deregulation Act. Go ahead, Neil. Thanks.
Yeah, so let me actually start. I'm here mostly to talk about the business cases, but let me start by talking about a pro bono death penalty case called Kansas versus Cheever that I'm arguing in a couple weeks. And here's why this is interesting. I mean, criminal law is the place in which, at least in the Warren Court, you thought it was the Democratic-appointed justices who were siding with the criminal defendants and the Nixon appointees and so on siding with the government. But, this Supreme Court has turned out to defy those predictions. I mean, Justice Scalia gave a speech, I think, over the summer in which he said, I am the poster child for the criminal defense bar. And there's something very true about that. I mean, when you look at the decisions in the Confrontation Clause area, in the jury trial area, and the sentencing guidelines and the like, Justice Scalia has really staked out an originalist position that is remarkably pro-defendant. And so this case is one of those cases that is raising it. It's my first death penalty case that I'm arguing. And in the case, you have a guy named Scott Cheever who had been taking methamphetamine straight for 9 days, hadn't slept, and the police he's at someone's house, and the police get wind that he's there, and they go to the house, and he's hiding upstairs, and as a sheriff comes up the stairs, he panics while he's very high on methamphetamine. He'd taken something like 150 units, and I think it's something like 80 is enough to kill an ordinary human being. And he takes his gun out and shoots the sheriff point blank. And he's indicted for murder of the sheriff. He's indicted first in state court in Kansas, but the Kansas Supreme Court then declared the death penalty unconstitutional because it violated the jury trial right in Kansas versus Ring. So the case was then moved to federal court. And while it was in federal court, Cheever said, here's my defense. My defense, I did it. There's no doubt. I'm not putting on an alibi defense or anything like that. But I lacked the premeditated intent for first-degree murder. I was high on methamphetamine, and it undermined my ability to reason for and premeditate for purposes of first-degree capital murder. And the federal government, under Federal Rule of Criminal Procedure 12, said, okay, well, you're putting on a mental state defense, and therefore we get to have a psychiatrist evaluate you and ask you questions. And so they did that for 5 hours. The trial was going to happen in the federal system, but then due to some complicated things with the lawyers not being available or something, somehow the case got moved back to state court. In state court, Cheever put on that defense, called a psychiatric expert who said, he's high on methamphetamine and the like. He couldn't have reasoned for premeditation to first-degree murder. The state then introduced all of that evidence from that 5.5-hour evaluation of him against him. And the Kansas he objected, Cheever objected, his objection was overruled. He objected on compelled self-incrimination grounds and said, hey, you can't use my words against me. The trial judge rejected that, but the Kansas Supreme Court unanimously said Cheever was right, the government of Kansas was wrong, that Cheever wasn't trying to put on a mental state defense like insanity or something like that. He was simply putting on the defense that he lacked premeditated intent because of the methamphetamine, and you couldn't use those his words to the psychiatrist against him. The Kansas Solicitor General petitioned for certiorari from this unanimous Kansas Supreme Court decision, and it was granted. And so the question in the case really is, what are the metes and bounds of the self-incrimination clause, and what are the rules about waiver? Interestingly, Justice Scalia, when he was on the D.C. Circuit in 1984, wrote an opinion basically saying, hey, all this stuff about waiver of self-incrimination rights is pretty much made up. It's all for policy reasons. And he said maybe those policy reasons are good, but they're policy reasons nonetheless. And the structure of that argument is the same one that's been playing out in all of the Justice Scalia opinions about the Confrontation Clause and about the sentencing guidelines, which is how much in a constitutional, how much in the guise of constitutional interpretation are we willing to take policy arguments and incorporate them? And this court has been pretty reluctant to do that, particularly in the criminal context. And so we might see a rather surprising result in the case because of it. Now, with respect to the business community cases, I think.
And by the way, if I can interrupt, that was one of Neil's 5 cases.
Yeah, but I'm not talking about all of them. Don't worry. So you'll be bored.
It's just pretty remarkable, really,
So,
to have that many. At any rate, and they're very different. So
they're all different.
Very different.
This one, which I'm actually not arguing, but our firm's involved in, is called Northwest versus Ginsburg, and it involves preemption. And I know folks in this room generally know what preemption is, but for those of you watching, preemption is the idea that federal law trumps state law, and it comes from the Constitution, from Article 6, which says that federal law is supreme over state law. This is very important to the business community because there are any number of state laws on any number of things that national businesses that operate in lots of states find difficult. And if one state has a really restrictive rule, say on labeling of cereal or something, if you're a national group like Kellogg's or something like that, it's very hard to sell different cereal boxes to California than to Vermont and to Iowa and to Alabama and the like. And so preemption is a constant theme of the business community before the Supreme Court. I argued a case a couple years ago about greenhouse gas emissions, in which several states said that the nation's power plants were contributing to global greenhouse gas emissions, and that there was a state common law cause of action against them. And this is when I was in the Obama administration. We actually sided with industry and said, no, that Clean Air Act preempts all of these different state law things. It sweeps it away, and there's one federal standard, not 50 individual standards. The Supreme Court unanimously accepted that preemption argument in that case. And in general, I should say, this court, the Roberts Court, has been accepting most of the preemption cases. There have been a couple notable exceptions, but in general, I think they have a fairly robust view about preemption and a robust view about the national market. Here's why this case is important. It's, again, the question about, is the Roberts Court more friendly to businesses than it is to other interests, to consumer interests and the like? Judge Posner, one of our legendary Court of Appeals judges, authored a study last year. He sits on the Seventh Circuit, and he found, surveying decisions from 1950 on, that the Roberts Court was remarkably pro-business, siding with business approximately 62% of the time, as opposed to 42% of the time over that time period.
But Neil, those cases don't always break 5-4.
Oh, sure.
I mean, you're.
Oh, absolutely. Oh, no. When I say Roberts Court, I don't mean to say it's Roberts alone. Absolutely not. I mean, I think you're exactly right.
Justice Breyer.
I'd clerked for Justice Breyer. I think he's, again, I think a bunch of them. I don't think it's a left-right thing. I think the more interesting statistic from Judge Posner is this. He says, of the 10 most pro-business justices during, his time period of approximately 70 years, 4 of them are currently serving on the court: the Chief Justice, Justice Alito, Justice Thomas, and Justice Scalia. And of the 10 most anti-business justices, only 1 is currently serving on the court. That's Justice Ginsburg. And I think that there is something to that. And I think this case, the Ginsburg case, is perhaps a good illustration of where I think the court's likely to go. So you've got this guy. He's in Chicago. He belongs to to a frequent flyer program, Northwest Airlines. And Northwest Airlines, this guy evidently is complaining a lot about various things about the program, not getting all of the benefits and so on. And there's a clause in the contract which says that if you're, I guess, a persistent griper or something like that, they can boot you from the program.
I mean, who knew that? I mean, I complain all the time. I gotta be-
Well, call Mr. Ginsburg. So he brings the suit in Illinois in state court and under Illinois common law, and the Illinois courts accept this idea and say that basically, that there's Illinois common law, state law causes of action. And the airline says, as the airlines are wont to do, no, the Airlines Deregulatory Act sweeps away all these contrary state laws and imposes one uniform federal standard. And so the question in the case is, how do we read this federal law against the tapestry of all these different state laws? What was Congress intending to do here? Were they trying to get rid of all these state law causes of action so that airlines could operate under one metric, or did they really want to have 50? And, every so often the court accepts the idea that Congress really did want 50. But as I say, I think, the way, I shouldn't say the wind is at the back of the airlines, but whatever, the trend here has been very much in favor of preemption. Before I go, let me just mention the patent area, because I do think this is another area in which the Supreme Court is becoming increasingly concerned, and rightly so. The patent system, in my view, is getting close to broken. I think Mike said that the grand jury will indict a ham sandwich. Well, the Patent and Trademark Office will patent a ham sandwich, or truthfully, a grilled cheese sandwich with its corners cut off. That is, patents are really important. They incentivize innovation and so on. But if you can read patents really broadly, then they become tools to block innovation, because people say, oh, you're infringing on my patent, and it's very hard for companies, such as Google, when they put out a phone, and to have 250,000 different patents that are potentially at issue and potentially bases for infringement. And so there's a huge, robust industry. It's kind of the old tort industry about accidents and so on has moved very much, and those lawyers have moved very much into this space representing non-practicing entities. And yesterday the court took two different cases about a mechanism to rein in kind of abusive patent litigation. And the mechanism is Section 285 of the Patent Act, which says that in exceptional cases, fees can be awarded against a litigant. And so if you are a filer and you don't do your due diligence, which I think everyone acknowledges to have happened in the Highmark case, you haven't really done all of the work necessary before you march into court and say, hey, you're infringing, then the defendant should get their fees back, and there should be some penalty for bringing such frivolous litigation. That's what Section 285 is about. And in these cases, the Federal Circuit has been reducing the amount of power that Section 285 has. And it is really one of the few tools that defendants have in patent cases, because unfortunately in the patent cases, they often go to discovery. They often have lots of stuff. It's very hard to kick them out on the pleadings. They get very technical. Anyone who's ever done a patent case would know that. And so industry, I think, is rightly concerned that 285 needs to be restored to its original position. And Megan's firm was instrumental in helping us frame this argument to the court. And I do expect these cases will be, two of many, both before and prior terms and in the terms to come, in which the Supreme Court is becoming increasingly involved in the patent sphere. Last year it was the Myriad Genetics case. Last term was the Myriad Genetics case about the patentability of the human genome. The Supreme Court unanimously reversing the Federal Circuit and saying that the human genome is not patentable. And they're becoming increasingly comfortable getting into this space and very comfortable reversing the Federal Circuit. I had given you the rates of reversal of the Sixth Circuit. Well, the Federal Circuit isn't isn't too far behind the Sixth on reversal rates.
Let me just ask you kind of just to step back too, and I mean, in talking about this, kind of the court being increasingly willing to step into some of these cases, why is that important? I mean, why are your cases important this term? What's the significance of this? What impact could it have? As like, why should I care about that?
Right. Well, I think everyone care. The great thing about America is that it is an innovation society. I mean, you look at other countries around the world, and maybe they've got natural resources in the Middle East, or maybe they got a billion plus people in various countries. But this country does innovation extremely well, and it's the genius of it's the engine of our economy. And we should care about this, because if the patent system gets out of whack, a lot of those innovators go elsewhere. I mean, I'm in Silicon Valley every couple weeks, and I can tell you they're worried about this, and they're thinking maybe this isn't the place to set up shop. And so that's a real cost to America if our innovation starts moving offshore.
All right. Anyone want to weigh in here? Or? Okay. Thanks. Should we move on to Nick, or you want to step up? As I said, I'm sorry Neil has to leave, but I think we can all give Neil a round of applause for that. Thank you very much. Thanks so much, Neil. And we will look forward to your arguments, which of course will not be televised, sadly. But that's a whole nother topic. Nick is going to summarize three, one of which he and Mike have already started kind of talking about, bond. Do you want to start with bond, and then we'll go to the recess appointment case?
Sure.
Or however you want to do it.
Yeah,
Thank
that sounds
you so
great.
much.
So I know why you all are here, and I know why you all are watching C-SPAN. You're looking for predictions as to how these cases turn out.
Oh, you're not going to be contrarian on this, are you?
Possibly you're you may be on the phone with your bookie right now, getting ready to place bets on these cases. I just have to warn you, I was on this panel last year and I went 1 for 3. So I want to urge you to take my predictions with a grain of salt, but I will take a crack at
But you're due for a change of luck.
No, I'm going to do better this year. Yeah, I'm definitely going to do better. So bond is my favorite one, and I'll confess some involvement in it. I've filed an amicus brief on behalf of Cato. Mike's already teed it up a bit. It has great and lurid facts. Mrs. Bond discovers that her husband is having an affair with the neighbor. And so she does what really anyone would do, which is she gets a bunch of toxic chemicals and spreads them on the doorknob and on the doormat and the car door and the mailbox and so forth of the neighbor. The neighbor successfully avoids that. Mostly she gets, I think, a little minor thumb burn at one point. So it turns out it's not terribly harmful, but it could potentially have been quite harmful. Now, so this kind of conduct is obviously all kinds of state crime, right? There's a lot of different state crimes that you're committing if you do that. But she's actually tried by an ambitious assistant U.S. attorney under the Chemical Weapons Convention Implementation Act. And now...
It wasn't me.
I know. Mary Beth, come on.
So, the Chemical Weapons Convention Implementation Act probably wasn't, they weren't thinking about this sort of set of facts maybe when they wrote it, but it seems to fit. Seems like she might fit under the statute. She's used these chemicals. She's tried to harm her neighbor, and so seems like it might fit.
Has she ever been to another country? Or
No real. So we have this treaty, the Chemical Weapons Convention, and Congress passed the statute, the Chemical Weapons Convention Implementation Act. She's tried under this statute, and she says, where does Congress get power to enact this statute? Whence the congressional power? And what we normally do is we flip open Article 1, Section 8 of the U.S. Constitution, which is a list of congressional powers, and she says, I don't see any power over this. I don't see any power that concerns chemical weapons. And the government says something interesting, which is it doesn't matter that you don't see it here in this list because we've entered into this treaty, the Chemical Weapons Convention, and so that automatically gives us the power. Congress automatically has power to pass a statute that implements a treaty, even if they wouldn't have had the power to enact that same statute absent the treaty. And for that proposition, the government cites a case by Justice Holmes in 1920 called Missouri v. Holland, which seemed to say that. If a treaty, if we enter into a treaty, Congress automatically gets the power to pass legislation pursuant to that treaty, even if they would have lacked that power otherwise. And I've written an article in 2005 arguing that that's wrong. Justice Holmes said that, or implied that, I guess, in a 5-page opinion with no reasoning whatsoever. I've argued that that's wrong, and now Mrs. Bond is arguing that that's wrong and that Congress lacks the power to, that the treaty cannot give Congress this power if Congress lacked the power already. That's what Mrs. Bond's arguing, and that's what we're arguing as amicus. You can imagine if Missouri v. Holland is right, this is a potential end run around limited congressional power, right? There's this list of powers in Article 1, Section 8, but if Missouri v. Holland is right, or if the government's right in this case, then Congress has all those powers, plus any power that they can enter into, any power concerning any issue on which they could enter into a treaty.
And that seems like pretty much anything.
And the conventional wisdom is there's no subject matter limitations on treaties. So if you can find a foreign country, if you can find Zimbabwe and make some agreement with them about, you know, mandating that people buy insurance or requiring that there not be guns near schools or whatever it is, then suddenly Congress would get that power even though they lacked the power beforehand. So that's really what's at issue with the case. It's this very fundamental idea about whether Congress's power is limited or actually increasable by treaty. So that's what's at issue there.
So what's your take on where the court may come down on this? I mean, you know, the Chief Justice, where's he going to be?
Well, so it's hard to predict. On the one hand, there are many ways for the court to actually dodge the fundamental question in this case. So they could construe the statute narrowly, or they could construe the treaty narrowly, or there are ways around taking this issue head on. And so they have plenty of sort of exit ramps from this issue. On the other hand, though, they did grant the case, and the case is not that interesting unless you're trying to get at this issue.
And the facts, of course.
And the facts are, the facts are lovely to talk about, but they're suggesting that they may well be interested in it, and moreover, I filed a motion on behalf of Cato for divided argument time. Our brief is squarely on this issue. You should overrule Missouri v. Holland, and the court's still considering that. So if they grant that motion, that'll be quite a signal that they actually want to take the big issue head on. So our fingers are crossed for that.
Anyone want to weigh in? Anybody?
Yeah, I'm just wondering, was there never any discussion of this going back to the state? I mean, it really is pretty amazing that the government has pursued this to this extent.
So I'm sure.
Well, this is her second. This is the second run at this too at the court. So
yeah, so the government clearly regrets this. I mean, this was a big mistake. It's quite an odd how this came to pass. I think the government first the government took the position in the Third Circuit that she didn't have standing to make this argument. Mrs. Bond couldn't make this argument. They convinced the Third Circuit of that, and then acting Solicitor General Noel Canning confessed error. So of course that's not right. Of course she has standing. And the court says at 9-0, yeah, of course she has standing. And so now we're back in the Third Circuit on the merits. And the Third Circuit said on the merits, we have to, Congress does have this power, see Missouri v. Holland, but we urge the court to rethink this. This seems like it might be crazy to us. So that's what tees this up for the Supreme Court.
all right, well, let's talk about the recess appointments case,
Okay.
which is, I mean, we talk about originalists on the Supreme Court. They're all going to kind of have to be originalists in this one, right? I mean, there's not really any cases.
Yeah, that's what's interesting about all three of these cases, actually. So each of these is about the scope of the power of a branch of government, legislative, executive, and judicial. So these are fundamental separation of powers cases, and there aren't that many cases like this. And so this really puts the court back to considering first principles, really digging into text, digging into history. And so, for constitutional scholars, these are very interesting cases because they're really driven by first principles. And this Noel Canning case is driven by first principles. So this concerns President Obama appointing various members of the NLRB, so the National Labor Relations Board. NLRB takes an action, and Noel Canning says you don't have power to take that action because you don't have a quorum, because a couple of you were not appointed properly. not appointed properly, and thus you're actually just private citizens, so there's not enough folks there to do anything. So that's the argument of Noel Canning. It's implicating this question of what's a proper appointment. Now, as a general matter, what the way an NLRB member or most senior officers would be appointed is the president appoints and then the Senate confirms, right? Senate gives advice and consent. However, there is also the recess appointments clause of the Constitution. So I'm just going to give you that, since this is actually going to turn on constitutional text.
And you do carry that in your pocket, right?
I
that
do. Actually,
Constitution?
took it out of my pocket already. The president shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. Now, it's easy to imagine what was the sort of paradigm case that the framers would have been thinking about when they wrote that, right? You can imagine the Senate is out of session and some crucial general is killed on the battlefield, and the president has to be able to appoint the new general rather than waiting for the Senate to come back into session. I think they were probably imagining something along those lines. Kind of an exigent circumstance. You shouldn't have to quite wait for the Senate. What happened here, you might recall, was so the Senate was holding what they call pro forma sessions. So they were, a senator was coming in and kind of gaveling the place to order for a few minutes and then gaveling it closed. But 98 or whatever of the senators were at home, and the president said, that's not a real session. They're not really in session. They're really in recess. And so that triggers the recess appointments clause, and I can just appoint these folks even though there is this kind of pro forma thing going on. So the case raises first that sort of narrow question of what about these pro forma sessions? Does it matter that the Senate the Senate itself claimed to be in session, right? The Senate itself thought that it was in session, but President Obama said, no, that's not a real session. So one question is, what do we make of those pro forma sessions? Do they count such that the recess appointments clause is not implicated? But the DC Circuit actually wrote a much broader opinion about this and much more interesting than it necessarily had to be. So one question is, the recess appointments clause, again, fill up all vacancies that may happen during the recess with a capital R and a definite article, the. And the DC Circuit said, you know what, that actually means the recess between two sessions, that is between two kind of capital S sessions, the one that ends at the end of a year and the one that begins at the beginning of a year. It doesn't, so inter-session recesses. It doesn't include intra-session recesses. Those are that's a big deal, right? So that's the Senate has many intra-session recesses, but only this one per year inter-session recess. So that was one kind of dramatic major holding of the DC Circuit. Then though, and they went ahead and decided a yet even more important and dramatic point. Again, the president shall have power to fill up all vacancies that may happen during the recess. Now, as I suggested already, a straightforward understanding of that text and a straightforward understanding of the animating idea would be the recess occurs while the Senate's not in session, right? The general is killed while the Senate's not around. That would seem like it's the paradigm case, and it would seem like the clearest reading of this text that may happen during the recess. Now, the executive branch has taken the position for 180 years that actually means exist, right? The vacancy exists during a recess, even if it happened when the Senate first occurred when the Senate was first in session. Executive branch has taken that position for 180 odd years, and the DC Circuit said no. What it means actually is the thing has to occur. The vacancy has to first begin during the recess to trigger this clause. So it's quite a dramatic holding, and the court has never kind of squarely answered this. So they're going to be, again, kind of dealing with this on first principles. The D.C. Circuit was having a real hard look at the text and the history, and that's so it's it's almost
But it
first
would have
crack
a
at this.
dramatic, I mean, as you were saying, I mean, Republican administrations, Democratic administrations make use of the power to make recess appointments. If the D.C. Circuit's opinion is affirmed, that would dramatically curb kind of that time-honored little tool.
Yeah, so it on its face it looks like a little tool. This tool about recess appointments. Say, well, how often are they in recess anyway? But everything that happens in Washington happens in the shadow of these fundamental decisions. So how you decide on how recess appointments works changes the balance of power as to regular appointments, right? Appointments when the Senate is in session. Can the president just wait it out, wait for a recess and then get the person he wants or not? So it shifts the balance of power as to appointments generally. And it's broader than that, right? It shifts the balance of power as to everything because appointments are a bargaining chip. So this is, it's one arrow in the quiver of the executive branch if he gets to do this, or of the Senate if he doesn't. And, you can win concessions about other things. Maybe we should, postpone Obamacare unless you let us, or maybe we should, let Obamacare go through unless you let us appoint X people. So, everything that every negotiation between the president and Congress happens in the shadow of these fundamental rules. That's why this matters.
All right, let's talk about the last powers case,
Okay.
bankruptcy courts, and then we're going to open it up to questions from the audience. So we should probably, well, this one's kind of the least significant, I guess, right? Of the
This
three.
is extremely obscure. I'm going to do 30 seconds on it maybe. This is called Executive Benefits Insurance Agency v. Arkeson. This concerns bankruptcy judges. Bankruptcy judges are not Article III judges, right? So Article III judges have these powers which are, or have these particular constitutional protections. They have life tenure. Their salary cannot be diminished, et cetera. And bankruptcy judges don't have those things, so they're different. So the question arises, what kinds of things can you give to bankruptcy judges to do versus what kinds of things have to be in an Article III court? And this is, the facts are quite obscure and complicated about this particular kind of claim, fraudulent conveyance, and whether this fits within this private rights, public rights distinction. This is all extremely complicated and obscure, and I'm not going to burden you all with it, except to try to give you what's important about this case. This is, again, this is really about the structure of government. It's about the structure of government, what Article III means. I'll give you two possible visions. One vision is it's really protecting individual rights, Article III. It's really your right to a certain kind of adjudicator of your claims. It's really about personal rights. If you have that conception of it, then you might say, well, I guess it's waivable then, right? You could consent, if it's really about my personal rights, I guess I could waive it or consent to a different kind, right? So that's one conception which would lead you in the direction of, I should say this case implicates whether you can consent to this or not, whether consent matters. If your conception of Article III was it's really protecting individual rights, you might say, well, yes, then you ought to be able to waive it if you want, I suppose. On the other hand, though, you could have a conception of this as important structurally. That is, it matters not just to the parties who are involved in this case, but it matters to us all in a sense, right? It matters to us all in a sense, the power of the judiciary, Article III. And as to that, you wouldn't necessarily think some particular party ought to get to waive that. So that's what's at issue here, is how you conceptualize that. In a way, it's similar to the other two cases, right? These are deep kind of structure of government cases, and everything that happens in Washington happens in the shadow of these sorts of cases. That's why they matter.
All right, thanks very much. Does anyone else want to add anything before we toss it open to questions? No? Predictions? It's going to be an interesting term.
Oh, yeah, Noel Canning 9-0. That's our
The
case.
recess report,
Yeah,
yeah.
exactly. That's the one for that.
I don't know about 9-0, but I don't think it's going to be 5-4. I agree. I think it's actually a pretty easy case. I think it's actually one of the clearest examples of unconstitutional behavior by this president was trying to appointing these folks per the recess appointment clause when the Senate itself claimed that it was not in recess. To me, this is pretty clear, actually. So I should have said that. Yeah.
And also, I mean, it was kind of when they were appointed, they would have been able to serve for 2 years, right? I mean, it was right at the beginning of a new session of Congress. So I kind of wonder if this was just like, they just pushed it a little too far here. I mean, recess. Okay, audience questions. Anyone?
Hello. Hello, we have a question over here.
Oh, okay.
If any of you had a chance to look at it, any comments on the Oklahoma case concerning the restrictions on abortion drugs?
This is a case that, this works out well because we're going to talk about some of the pending ones. You want to take that one?
Jan was
Megan
very
has
smart.
that.
She said someone will ask about that case. So someone needs to at least
Well, I'm
look
glad
at
you did
it.
because I forgot about it.
Thank you. I didn't do it. I don't think it's going to get teed up for decision this term, perhaps at all. This is a Oklahoma statute that purported to restrict the timing, effectively restrict the timing of chemical abortion, like RU 486. And the way they did it, they require prescribers to abide the FDA-approved method for prescribing these sorts of prescriptions, and that results in a narrowing of the window. What has happened is prescribers have gone sort of to off-label uses with a slightly different protocol and a longer window in the early stages of pregnancy when RU 486 and its equivalents can be used. Oklahoma said, no, we don't like that. They seem to have built some record about that being the off-label use being somehow riskier to women. I don't know if that record is legit. I'm sure the state court didn't find it so. And the law was struck down by the trial court in Oklahoma, I think, but the cert petition came out of a very terse state Supreme Court decision that sort of quickly and perfunctorily, it seems, mentioned Casey and moved on to affirm the invalidation of the law. So the court granted cert, which seems to have taken some of the reproductive rights folks by surprise, but then it simultaneously referred to statutory interpretation questions to the Oklahoma Supreme Court. I'm not going to belabor those with you, but they will determine how appropriate the case would be for the Supreme Court to hear. Sort of meta level, I think in the news, Arizona's law, a cert petition was filed on the Ninth Circuit's invalidation of an Arizona, different kind of abortion restriction. So there's this movement out in the press that the court may hear one of these cases. I think the Oklahoma case is not likely to be on a fast track because the Oklahoma court, I don't think, has a deadline to answer these questions that seem to require perhaps more work than was required to do their affirmance that is the subject of the cert petition. So I think they've raised very interesting questions about how chemical abortion fits in under Casey and Gonzalez, and sort of how do you gauge undue burden under Casey versus the availability of methods that seem to be going on in Carhart. But it's been a while since I've read those original decisions, so I'm not going to say much more than that, other than it's out there and people are worried about it, and you see Linda Greenhouse and folks writing about them, so people will be watching those.
But it doesn't sound like you think we'll get it this term.
The Oklahoma court would have to be super fast.
Turn it around quickly. Anyone else? Yes.
While we're talking about cases the court may grant, I know we saw some high-profile cert petitions in the HHS abortifacient contraceptive mandate thing, particularly like the Hobby Lobby case recently. Anyone able to comment on those, which one might be seen, or if those might be heard this term?
Anyone want to tackle that?
I haven't followed them closely enough to know.
Me either, except I think the consensus is they're barreling their way.
Yeah.
So the court, it could be, although I don't know that they'll get them in time for this term. You think?
Cert petitions. There's one from the First Circuit involving a search of a cell phone, which sort of raises the issue again of the Fourth Amendment in the world of high technology that was sort of addressed more by the concurrences in Jones than anything else. Any thought about whether the court's going to try and wrestle with that question anymore this term?
Yeah. Well, wait, let Mike was going to make a point on
the HHS?
Yeah, and then we'll go to your question, sir.
Oh, just real quickly, I'm not entirely sure of the timing on the Hobby Lobby. It's conceivable they could wait. There's an underlying issue about whether or not businesses have this underlying right. There's also a series of challenges brought by Catholic institutions as well. and they might wait until those percolate up and take the whole smorgasbord at the same time.
Okay, thanks.
On the electronic surveillance case, I don't have strong feelings or haven't really reviewed the papers on this particular one, which seems to be the search incident to arrest doctrine and how far it will let you go in searching the contents of a cell phone. Not such a big deal, I suppose, if it's sort of an old-fashioned flip phone. People get quite nervous about it when you're talking a smartphone that essentially has everything about your life. I'm not going to venture a prediction on that, either the cert likelihood or otherwise, but there is this movement, and I'm sort of waiting for a case to percolate up on some of the many unresolved questions under sort of the Fourth Amendment, ECPA, Wiretap Act rubric that the courts are struggling with. There have been a couple of cert petitions over the past couple of years that didn't get granted. You can, I guess, infer from that the court's not looking to bite on this quite yet. They did Jones, which, as we know, is not that context about all of the things we read about in the newspaper. But I think, they'll get involved. I was involved in the NSA versus Clapper case last term, so these issues are very salient, and we'll see. I think they will hit the court in the next couple of years in some form or fashion. But they're often in these cases are often litigated by defendants in criminal actions, so they're often not sympathetic facts for the airing of the true constitutional questions.
I'll just agree with most of that. I think that
good.
I think that the Supreme Court is going to have to take a crack at the Fourth Amendment and new technologies, and this is a huge area with lots of unresolved questions. So, and the technology is evolving so quickly. I think the court is going to have to think about what its framework is going to be for deciding these kinds of questions. So, I think you actually will see. I don't know about that case in particular, but I think you're going to see many such cases in the next, say, decade.
I think we have time for one more question, and then we're going to have to call it a day.
Yes, for Nicholas. You talked about the power of bankruptcy judges, but I wonder how that would apply to magistrate judges. In a civil case, if all parties agree, the magistrate judge can make a decision as opposed to just a recommendation to the district judge. And there's a lot of pressure on parties to agree to that, because otherwise it may be 10 years before you get a trial for a district judge. But if the idea is, well, the parties can't waive it because it's the right of the public, is that going to affect the way civil litigation is done in the federal district courts?
Yeah, it's a great question. I'll just say this is a hugely complicated area, and it implicates magistrate judges, it implicates territorial courts, it implicates military courts. There are a lot of non-Article III courts in the world, and quite what those folks get to do and why is a very unsettled area of law, and the court's been very confusing about it. So yes, this has implications for that, has implications throughout. I guess I'd say, two of the big themes of these cases have been, one, consent. So are the parties okay with that? And should that matter? Should that be dispositive? That's a sort of running question, running theme of these cases. And second, what kind of Article III review is there ultimately? So is there ultimately an Article III court that gets to take a crack at the question at an appellate level? And what kind of review is that? Is that de novo, or what's the scope of review? These are two of the themes that run through these cases, but quite how these factors work or how they get balanced, it's really quite unsettled now, and frankly, I'm afraid it's going to still be unsettled after this case comes down.
I am told we have actually time for one more question, so this will be the last question.
For the Mount Holly disparate impact case, could you comment a bit about the history preceding it and how Magner, that case was pulled controversially, and then the HUD reg came out afterwards? How do you think those circumstances will come into play in the decision?
Well, again, I think the major significance of the HUD reg will be whether or not it affects Justice Scalia's view of the statute. I don't think there's any question that Justice Scalia would interpret the statute not to incorporate a disparate impact. Question is whether or not he might defer to HUD's regulation. I suspect he won't, because he's recognized that it's not as if an effects test is just a first cousin of the intent test that's really in the statute. It's in many ways, it's dramatically at odds with the purpose test, because the purpose test prohibits you from considering race, and the effects test basically obliges you to do so. But I think that's one of the reasons they've been slowing everything down to get to the court, because they wanted to get this HUD reg out before the Supreme Court considered the case.
All right. Well, we're going to have to end it on that note. And let me just say again, thank you to our host, the Federalist Society, Lee, Jean. Thanks very much for everything. We very much appreciate you, and thank you to C-SPAN, and a huge thank you to the panel. I think that's evident that really this was the panel to analyze this upcoming term. So I want to say thank you very much, and thanks to all of you for coming.
Thank you.